everyone. My name is Katie Egan, and I am with Foley and Lardner's Marketing Department. On behalf of Foley, we would like to thank you for participating in our Consumer Finance Web Conference. At this time, all participants are enabled in listen-only mode. Please note that in order is being recorded, the presentation portion will last approximately 60 minutes. If you have any questions, you can enter them in the Q&A pod, and at the end of the presentation, we will get to as many questions as we can. In the Files section of your screen, you will find a copy of the presentation slides for download. The Files section also holds a very important document for any attendees seeking New York or New Jersey. A 4-digit class code will be announced during the presentation. You use that code to complete the form and then send it to me at kmegan@foley.com immediately following the presentation. My email address is also listed in the housekeeping notes section of the web conference, and it will be available on
Katie. Welcome, everyone, and thank you for attending our program on the Telephone Consumer Protection Act today. Given the rapidly increasing activity under the statute, we expect to do updates annually, if not more frequently, from here on out. As Katie said, my name is Marty Bishop. I'm the co-chair of Foley and Lardner's Consumer Financial Services practice, and I'm also the vice chair of the litigation department here at Foley. We're very pleased to have you here for what I expect will be an informative and stimulating discussion on this statute. Parties with whom they had no established business relationship, and as a result were hit with some hefty penalties under the statute. Each other unauthorized fax meant an automatic fine of $500 or $1,500 if the conduct was willful and the judge in the case thought enhancement was appropriate. By the early 2000s, however, these cases became less frequent. While fax cases are still filed today, what we're going to focus on is the new wave of TCPA. Some compelling statistics. This slide here shows the number of TCPA cases filed from 2008 to 2012. The reason for the exponential growth in TCPA cases is not 100% clear. However, we do have some ideas of the possible cause. First, you can make a lot of money by bringing litigation under this statute. Prior consent using an auto dialer, making about 5.9, almost 6 million calls over a 5-year period, and the exposure for these calls was just under $9 billion. The case settled for a fraction of that, $17 million, but needless to say, these cases can be extremely serious from the perspective of exposure. Another reason for the exponential growth, no doubt, relates to the ongoing wireless substitution that number continues to grow. In December last year, the Center for Disease Control and Prevention found that wireless substitution exists in more than 1/3 of American homes. That is about 35 to 36%. That's up from less than 3% in 2003, which is what this chart here demonstrates. Probably more significantly, over 60% of individuals between the ages of 25 and 29 live in households potential plaintiffs continues to expand. The TCPA was passed in 1991 with the purpose of limiting telemarketing practices that Congress found were an invasion of consumer privacy and a nuisance. Excuse me. The statute arose because pre-recorded calls, which it believed created a greater nuisance and frustration for consumers than live calls. Today we're going to focus on what we consider to be the hottest topics in TCPA litigation, and you're going to hear from some of the best in the industry. Prior express consent and calls to cell phones using auto dialers or artificial or pre-recorded messages. Then my partner from the Deep South, Christy Lawson, is going to finally, my close colleague and friend, Rebecca Hansen, will cover a variety of issues, including jurisdiction, the statute of limitations, class actions, and vicarious liability. Before we turn to the speakers, let me just draw your attention to some sources of additional information. Obviously, the TCPA itself is your primary source for governing calling activity. The second and third sources are the FCC's regulations. TCPA cases on our blog, the Consumer Financial Services Litigation Bulletin, which you can find at cfslbulletin.com. With that, I'm happy, pleased, and proud to turn this over to my
primarily on the pre-recorded message and auto dialer provisions of the TCPA. There are two sections that set this law. The first, 42 U.S.C. 227b1b, which is the slide that I have up there for you, applies to residential telephone or landlines. This section prohibits a person or entity from using an artificial or pre-recorded voice to deliver a message to a residential marketing call using this technology without express consent. With that exception, the Congress has permitted the FCC has empowered the FCC to exempt other types of calls from coverage. Here are the guidelines Congress gave the FCC when permitting certain types of calls to be made to landline. The statute's provision is that the FCC can exempt calls that will not adversely affect privacy rights and do not contain the transmission of an unsolicited advertisement. In response to this enabling language, the FCC has in fact exempted from coverage certain calls made to landlines. The FCC rules permit calls that are messages, even if they just have an incidental amount of advertising. Those are the rules with respect to landlines. The rules with respect to cell phones are completely different. By contrast, a call going to a cell phone, which would also include a text message to a cell phone, has to have any additional exemptions for calls made using an auto dialer or artificial or pre-recorded voice to a cell phone. Thus, to call a cell phone using a pre-recorded message or an auto dialer, you must have express consent. A lot of our talk today is going to be about what is express consent. Congress did not define express consent for this purpose. And the cases that arose and surrounded. Last year, the FCC considered and established new rules regarding express consent for telemarketing calls to landlines and cell phones using an auto dialer and pre-recorded messaging. My partner, Christy Lawson, will discuss some preliminary matters regarding the Do Not Call list, and then specifically the new requirements for prior express written consent, which takes effect October 16, 2013. So now I turn it over to Christy.
Call portions, and it's interesting that when preparing, I had always thought of a lot of the regulations and my understanding of the TCPA applied equally to do not call as it did to, as Mike mentioned, issues regarding pre-recorded and auto dialers. But there really is some distinct differences between the do not call list requirements and what Mike's going to talk about in his presentation. So I'm going to focus more on the high level layout of the do not call so that you can understand authorized under the TCPA to create a do not call registry providing residential customers with an option to basically opt out. Do not call me for telemarketing purposes. At that time, there was a lot of discussion as to, well, do you have to register annually? How often does this last? And the answer is that the registration on the do not call list continues indefinitely. So once you have registered a number, it is to stay telephone number. You simply can register your cellular telephone number on the same do not call list. Now with do not call, the primary basis of do not call is so that companies cannot make telemarketing calls unless the company, as Mike says, has prior written consent, and we're going to go into that a little bit more, but also unless the company has those individuals who are on the list at all times, so you must keep your list current. But you must also implement your list. So you have to have written policies, train your personnel, and record and honor the do not call request. The other major distinction that we will be focusing on today, and that the rules and regulations focus on, is a difference which means that an actual person used their finger to dial the number on their keypad, calling a specific customer from the list that they have of their customers' information. So if it is an actual person actually dialing the phone, then the company may make a live call to a customer, even if listed on the do not call registry, if the company has an established business relationship with the customer or the 18 months after that last transaction. So the issue regarding, well, are they an established customer means have they conducted business with you within the last 18 months? And a telemarketer or seller may call a consumer for 3 months after he or she has made an inquiry or submits an application to the company. Now, there's two primary regulators when it comes to do not call and TCPA. 2012, the FCC decided that to make it easier on all of the companies and for regulatory purposes, it was going to bring some of its rules in line with prior guidance that had been given in 2008 by the FTC. And what the FCC says in their February 15th, 2012 release is that they will require prior express written consent for all auto-dialed So one, it applies only to telemarketing. Two, the express consent is only if it's auto-dialed or pre-recorded to wireless or pre-recorded to residential. In other words, you can think of this as the robocall order. The order eliminates the giving a live message. You still have the established business relationship exemption. If it is a pre-recorded message, you do not, even if it's to residential. The rule gives 1 year for companies to basically get their ducks in a row, so it becomes effective October 16th, 2013. The rule also requires telemarketers about what this opt-out mechanism has to be. It has to allow a consumer to opt out with one touch, one button, while on the phone. Once they opt out, it's not opting them out of that particular call, but to all future marketing calls. And if how that person can opt out of receiving future messages. And that applies even if the person has previously given consent. Once they give that opt-out, they're out. The second thing is that call must end immediately once they hit the opt-out feature. So it's not as if they opt And then it requires telemarketers to also comply with the 3% limit on abandoned calls during each calling campaign. There had always been a 3% limit on the number of dropped calls. So in other words, this nice little voice tells you to sit on the line, and then someone will be with you momentarily, and then you sit, and then you get dropped and no one's there. That's what this is. The FCC rule was intended to maximize consistency with the FTC, as we stated, and the FTC's rules was the telephone sales rule, which requires express written consent for certain telemarketing calls. Under the existing FCC rules, the companies were not required to secure any form of consent to place pre-recorded calls to a residential line. That's one of the main acts. So they focus mainly on abusive marketing practices. So everything the FTC has come out with is going to be more related as to the Deceptive and Abusive Telemarketing Act, focusing more on the advertising aspect of it. Receive the calls. So that they had always had the rule in effect since 2008 that you had signed written agreement. However, the rule excluded a large portion of the companies that are on the call today, which were common carriers, banks, and other financial institutions and insurance companies. So your focus had primarily been on the FTC. So now that they're coming in line, the FTC guidance can give you some idea under the FTC rule only if it's telemarketing. Whereas FCC, you need to focus on any reason for the auto-dialed pre-recorded except for the exceptions that are listed in the Act. Paper, it can be an electronic or digital form of signature, including signatures that are in compliance with the e-Sign Act. These include things such as emails, website forms, text messages, telephone key press, or voice recording. Anything that allows the customer to receive electronic consent under the e-Sign Act doesn't mean that you can also provide the disclosure and opt-out language that you need to electronically. That portion still has to be in writing. In addition, the express consent rule does not allow their goods by saying, well, you have to accept our telemarketing calls. That's prohibited. So now I'm going to turn you back over to Mike to go through the auto dialer and pre-recorded message calls so we can draw those distinctions. Mike, back to you.
Thanks so much, Christy. Just to comment a little bit more on something Christy just said. Be provided electronically. It's simply that an electronic record can't be created with a voice recording or orally. So there is a difference in that regard with respect to an electronic record and an electronic signature. What I want to cover are auto dial and pre-recorded message calls which are not made for telemarketing purposes. Here the rules remain largely the same. And I've got this handy dandy little chart here. I think that no consent, none, is required to use an auto dialer to make a marketing call to a residential line because the auto dialer provisions do not apply to residential telephone numbers. Also, the 2012 TCPA order does not affect the FCC's existing exemptions from the prohibition when you're going to call it a cell phone, unless there's some kind of an emergency. And an emergency would not be, hey, we've got a great sale going on. However, only marketing calls are going to require prior express written consent. For purposes of non-telemarketing calls, let me put up the other chart here. For purposes of non-telemarketing calls, persons who knowingly release their telephone numbers to you have given you their invitation or permission what Christy was talking about. All that is necessary is that the person give you their number. There are lots of situations where this kind of consent is going to apply. These would include things like, for example, political calls. Calls to let you know that the school has been closed, that your package has been shipped, or a call from a bank to alert you that someone has stolen your credit card. These are examples of the types of calls that can be made to a landline using pre-recording. Of course, not many lawsuits are filed about these types of calls. Outside of blast faxing and telemarketing cases, most TCPA cases deal with debt collection. Think about why. Not many people are going to sue the Abraham Lincoln Elementary School for calling you to say, hey, school's closed today due to the snow. Few people are going to be too upset because the bank told them that a crook had stolen their credit card. But many, many debtors will try to level the playing field by asserting a TCPA claim if they believe they are being hounded unfairly by a debt collector. Telemarketing call will be treated. The FCC has specifically addressed debt collection, but a specific exclusion for debt collection wasn't created. It's more categorical, as it simply falls within the ambit of commercial calls that are not telemarketing. The FCC has concluded that you can make a debt collection call to a residential line using a pre-recorded message even without prior express consent, because it's not a marketing call. You all may have received these. A skip trace call would not be considered a marketing call. It's a commercial call, and most courts have held, with a couple of exceptions, that such calls would not be actionable. However, the same call, exactly the same kind of pre-recorded call made to a cell phone, enjoys no such protection because, as we discussed at the start of this, the FCC has not permitted carve-outs for calls made to cell phones. The only way you can legally call a cell phone with an auto dialer or a pre-recorded message the TCPA is essentially a strict liability statute. Liability often turns on the issue of express consent. Now, there have been lots of cases that discuss express consent, and this one, I think, is an example of how troubling the Seventh Circuit, which highlights the risks associated with calling numbers even if you think you have express consent. In Soppet, a creditor called the number of its debtor who had provided that number to them, but lo and behold, the number had changed. The number had been reassigned to somebody else. So in other words, the debtor had stopped paying on the line, it got disconnected, or they that cell phone. The Seventh Circuit has said that can give rise to TCPA liability. The key is not who was your intended recipient, but rather who was the party that was actually called, and did that person give you consent? Now, the Seventh Circuit obviously recognized that this creates quite a pickle for companies when they're believing that these are the proper numbers and they're trying to call, and all of a sudden they have this massive, potentially TCPA liability. In a case, in the Soppet case, Judge Easterbrook wrote the opinion, and he noted that he how you can help deal with this problem. One is have a live person, a real person, make the call first, and then switch to a predictive dialer after verifying that the cell number is still good. The second option, second idea he had was use a reverse lookup to identify who the current subscriber of the cell phone number is. I don't think these probably really give you a lot of comfort. They may minimize potential damages, but obviously these numbers using live calls to periodically check that a number is still good that you're using to call your customers. Another case, again out of the Seventh Circuit, a lot of activity in this area in the Seventh Circuit, a lot of significant cases in the Seventh Circuit. Another case that's very scary and will change the entire landscape of express consent is the Thrasher-Lyon case. In Thrasher-Lyon, a U.S. District Court judge certified an appeal to the Seventh Circuit on the question of whether providing your cell phone number to a company amounts to your consenting to be a car while she was out riding her bicycle. The car's driver was insured by Illinois Farmers Insurance. At the scene of the accident, Thrasher Lyon gave her cell phone number to the driver and the police officer on the scene. She later exchanged calls with Farmers Insurance using that same cell phone, and during conversations with Farmers, admitted that she'd caused the accident and that the cell phone number was reported to a collection agency who started calling her using an auto dialer. Thrasher Lyon sued, and she alleged that the calls were not permitted under the TCPA. The district court agreed, contrary to what the FCC rules are, and found, as a matter of law, Thrasher Lyon's provision of her telephone number to Farmers was not prior express consent to receive robocalls on her cell phone. The court concluded that providing a telephone number to someone to call requires that a person expressly consent to auto dialer calls. At the defendant's request, as I noted before, the district court certified this case for an immediate appeal. The Seventh Circuit has, I think, realizing how important this case is, set briefing and invited the FCC to file an amicus brief in the case. Some of the briefs in the case have been filed. The case is, though, now on hold as the parties pursue a court-required mediation, which I think is set for early June. So not clear when we'll have a decision in this case. Obviously, if it settles, we won't. About regarding express consent for these non-telemarketing calls, I think is in jeopardy, and we will need to schedule another webinar, as Marty suggested earlier. Moving on, what if a customer gives you express consent and then they want to withdraw it? The TCPA does not address whether a customer may revoke consent once it's given. Some argue that the FCC implicitly allows to someone is an invitation or permission to be called at that number, absent instructions to the contrary. These people assert that this absent instructions to the contrary language demonstrates that the FCC contemplated that consent could be withdrawn. There are a number of good, a couple of good cases, I think, that address this issue. The first is Geiger, and this case is currently on appeal in the Third Circuit. In that case, the court looked at this issue that the person knowingly releases their telephone number to you, not some point in the future. The next case is the Saunders case. Someone's got their line unmuted. Can you mute all lines, please? In the Saunders case, I think is a great case and can be an issue. In that case, the judge said that, look, if you give your cell phone number to somebody or you give it to a business, you've basically voluntarily given up any TCPA protection that you have, and you're really no worse off than all Americans were before Congress passed the statute in 1991. Cases. There's this kind of weird body of case law that seems to be developing, as best I can tell, only in the Western District of New York. In fact, one case there was decided along these same lines just last week, a week ago today, actually, on May 1st. And the theory there is that these TCPA cases are often brought with Fair Debt Collection Practices Act cases, and at least in this court, in the Western District, they're going case is going to allow a written revocation of express consent. Basically what they do are they cut and paste the Fair Debt Collection Practices Act cease and desist language and paste it onto the TCPA. These by an oral statement, they permit it by a writing, and they are basically adopting a wholly different statute as authority for that proposition. Finally, there are a couple of cases where so basically, I guess what we're saying is that there's kind of a split out there as to whether you can withdraw your consent or not. Given the enormous liability, though, that companies can incur for TCPA violations, we suggest that you adopt a conservative approach to express consent and to revocation. Even though you're not required to have express consent to make non-telemarketing calls, you should try to get it. On this question, was consent provided? Now, if you're a defendant in a case like this, would you rather be a defendant trying to rebut the plaintiff's adamant testimony that he didn't give you that telephone number with a written document bearing his signature showing that he did? Or would you rather try to rely on some debt collector's note saying that during some debt collection call that that collector no longer recalls, he made a note that the person So when it comes to revocation, what's the safest course? If someone tells you to stop calling them using the auto dialer pre-recorded message, are you going to stand on these few cases here we've talked about that are in an area of developing law, or will you adopt a more safe course? We recommend a practice of taking such numbers out of the auto dialer if a person objects, whether it be in writing or orally. We will continue to argue that it's not required, but if you have the opportunity to be proactive here, with the live dialing to verify that the number you're calling is still going to the intended recipient. These practices, and as Rebecca will talk about this, these practices might even persuade a judge not to enhance damages on you if you are found to be in technical violation of the statute. So this is a rapidly changing area. The cases are pouring in. I literally get alerts about new cases decided every day. The damages are huge. Statute. With that, I'd like to turn it over to Rebecca Hansen, who will speak about some of the odds and ends in TCPA litigation.
Thanks, Mike. Hi, everyone. I'm just going to hit on a few issues you can see here in the slide. I'm going to jump quickly from one topic to the next, but we just wanted to make sure you were aware of some important points on each of these issues. I'm going to start with federal and state concurrent jurisdiction. The TCPA is silent about whether there is federal court jurisdiction over private at the district court level, with some courts disallowing federal question jurisdiction in TCPA cases and others allowing it. And the issue finally bubbled up to the Supreme Court and in a case called Mims v. Arrow, which was decided last year. And in that case, the court acknowledged that the TCPA's language is state court-oriented, but it also noted that the TCPA did not explicitly make state court jurisdiction exclusive like other statutes do. So that ruling really opened the door to private TCPA claims in federal court because after Mims, including class actions. In terms of statute of limitations, as a result of MIMS, the federal courts, a lot of courts have found that they're not required to follow state law in adjudicating TCPA claims. For example, courts have held that federal law governs the statute of limitations for a TCPA claim and not state law. And since the TCPA is silent about a statute of limitations, the federal catch-all provision of courts that's simmering. The conflict is over whether state laws that prohibit class actions are trumped by the federal rules of civil procedure. There are states that prohibit class actions that seek statutory damages, like those provided in the TCPA. And some federal courts have held that the federal rule of civil procedure, Rule 23, the one that governs class actions, would govern the procedure of the case, and that rule would trump Michigan state law prohibits plaintiff from bringing a class action that seeks punitive damages. That court relied on MIMS and held that the court is required to apply Rule 23 rather than any state law. But there are cases that go the other way. Despite MIMS, the Eastern District of New York recently held that a TCPA class action could not proceed because there was a New York state law that prohibited most class actions that seek statutory damages. That court relied on cases of a court of a state, that language creates a limitation on the federal courts. The court said that its opinion was actually in harmony with MIMS because it says that the MIMS decision did not discuss how the TCPA's language about bringing a private action in state court applies in federal forums. So we may see this issue rise up to the Supreme Court over time. So in terms of once you're in, and that the case can be resolved on a class-wide basis. So basically, that means that if the court would have to inquire with each potential class member to figure out some threshold question of liability, then the class action would fail. In a TCPA case, one of the easiest ways to defeat a class action is to show that there would be some need to inquire with all the class members over whether they consented to receive calls or faxes or whatever the case may be. For example, the Fifth Circuit in Gene and Gene v. BioPay, in that case, the defendant had a including from individuals who had an established business relationship with the defendant. And the court took this to mean that they were going to have to ask each class member to determine whether or not they had consented. And the plaintiff couldn't show that there was a class-wide basis for distinguishing who had consented and who had. The court there found that it could presume that there was a lack of consent because the list came from a third party and wasn't collected specifically for this defendant, and class certification was granted in that case. So getting through to the class certification hearing can be a costly and burdensome event for a defendant in a TCPA case, especially when you actually have a good shot of showing that consent would be an individual issue that the court would have to inquire with each. The defendant had argued that they had all consented to receiving pre-recorded calls, and the consent came in various ways, including by email, through the company's website, over the phone, and verbally to sales representatives. And the defendant argued that discovery in that case, before they even got to class certification, would be unduly burdensome because to do even a cursory require the defendant to produce at least a large portion of the information from those files, despite the burden. In terms of federal pleading requirements, the courts, of course, are steadfastly applying the Twombly-Iqbal for the misconduct that's alleged in the plaintiff's complaint. We've seen cases where the court has rejected complaints merely because they're citing the language of the TCPA. For example, this Knutson case here, the plaintiff really just said that he had been called by equipment that has the capacity to store or produce numbers using a random or sequential number. Believe that he'd been called by such equipment. Some courts seem to require even more from a plaintiff in terms of pleading. In the Hanley case, for example, the court wanted the plaintiff to plead the number of calls he had received, when those calls were made, when the plaintiff had asked the defendant to stop calling him, and how the plaintiff made the request. I just wanted to point out that the private on the use of automated telephone equipment involving pre-recorded calls or calls to cell phones, even if he or she received only one call. But the private cause of action for violations of protection of subscriber privacy rights, so we're talking about the do not call request, that requires that and you use that defense by proving certain compliance measures. And the key to doing this is good record keeping. And you'll have to show that you had written procedures to comply with the national do not call rules, but the record showing training, you trained your personnel and any entity that's assisting you in the compliance with the do not call rules. And the last thing you need to show are records showing compliance with company-specific do not call requests.
And now we're going to pause for it is O, the letter O, E11. That is OE11. You use that code to fill out your form, and then you can email it to me at kmegan@foley.com. Back to you, Rebecca.
Thanks, Katie. Just a quick note on individual liability. As an officer of a company, to violate the TCPA, and just being merely tangentially involved doesn't cut it, but if you're personally authorizing the conduct, that can cause trouble for you. In terms of vicarious liability, you'll see on the slide the top couple of, but there are parts of the TCPA that don't contain such explicit language, and in those cases, the courts have found that the traditional agency principles apply. So that means for a court to find a principal-agent relationship, the principal must have the right to control the manner and method of work carried out by the agent, and for the agent must be able to affect the legal relationships of the principal. For example, the Thomas v. Taco Bell case, the plaintiff had argued that Taco Bell was vicariously liable for unauthorized text messages that were sent in connection with a text message marketing campaign conducted by the Chicago area Taco Bell Local Owners Advertising Association. And the court said that so really the plaintiff had to show that Taco Bell controlled or had the right to control the advertising agency's text message campaign. And the court found that the plaintiff failed to do this, and that was that for that case. Or entity, but courts are split over really if any person has standing to bring a TCPA claim. Some courts will allow the intended recipient of a call, message, or fax to bring such a claim, but other courts have held that even where the individual isn't the intended recipient, but the skip tracing services used by the defendant continued to bring up the plaintiff's number, and calls were placed. There were, I think, 70-some calls made to her, even though the debt that the defendant was trying to collect was not hers, was the cause of the identity. Case where the plaintiff was called by a marketing company on behalf of the defendant, but the marketing company had intended to call the plaintiff's roommate, and the number was assigned to the roommate, and the court found that to the extent that the plaintiff picked up the phone call, he was not the intended recipient of the call and therefore did not have standing to bring a TCPA claim. Fine, but as the court can treble this up to $1,500 where there's willful and knowing behavior. But the good news is that trebling is not required. And while a plaintiff might be able to point out that you've acted willfully because you intended to establish that the call was made because of some sort of mistake to avoid trebling of the $500 violation fee. So for example, if you call the wrong number because the plaintiff changed his home phone number to his cell phone number and you didn't know about the change, you still might have violated the TCPA by calling the number, technically, and you still are liable for that violation, but because there's a mistake involved, you might be able to convince the judge not to treble damages. Yes, if you have a question, you can enter it in the Q&A section, which is in the lower right-hand corner of your screen.
Looks like we have a couple questions, and I will take a crack at those, and anybody else wants to jump in, please. To be basically a machine that has the capacity to store telephone numbers and then randomly or sequentially dial them. In 2003, with the TCPA order in 2003, that was a big order where they not only addressed the do not call list, but also addressed some other things, including this. They The FCC has said that even if you intend to call and you list a number because, for example, these people owe you a debt, that can still qualify as an auto dialer if the machine you use has a capacity to store the number. So there's probably opportunity out there to challenge that as exceeding the FCC's authority. There was a case in the Ninth Circuit called Satterfield that did that. The other question here that I see is related to voice over internet protocol numbers. This, of course, is, do these rules apply to voice over internet protocol numbers? So the statute that deals with cell phones also essentially anticipates future technology. that would apply to a cell phone. So some voice internet protocol numbers you don't get charged for, and I think some you do. So it's going to depend really on that. And in the course of your case, you're about calls to that number. Katie, are there any other questions?
Yes, there are. I just emailed you a couple, Mike.
Okay. So this question, and I'll throw this out. I agree with it. How can this be an adverse outcome? Well, the Thrasher Lyons case is scary for this reason. The way the FCC has interpreted consent at this point for purposes of pre-recorded messaging and auto-dial calls is that all you have to do is give the number. So in other words, if I complete a credit application and I provide my Thrasher Lyon is that, wait a second, the fact that I said you can call me doesn't mean you can call me using all this special technology that allows you to call me many times a day or whatever. Notice to customers saying that you're giving us your cell phone number entitles us to call you using pre-recorded messaging or auto dialers. So it'll be a sea change. Obviously, people can adjust to it. All that had to happen was a number be given. So that's why I think it's an important case. Another one says if your telephone system has an auto dialer, but a person doesn't use the auto dialer to make the call, but instead manually dials it, isn't that a problem because the system has a capacity to make auto dial calls? How do you basically, this is an issue that it has been addressed by more commentators and people in speeches and things like that. I haven't seen a lot of cases around this issue. I have plaintiffs' lawyers all the time in depositions try to, for example, get a debt collector to say, yeah, all I had to do is definition to its logical conclusion. Your iPhone is potentially an auto dialer. It certainly has the capacity to store numbers, and when you press it, it auto dials it, if you will. This is an area that's going to develop in the case law. It's not very clear yet, but certainly the questioner is correct that this is an issue.
An express consent waiver, and is it enforceable? Does the purchaser of consumer accounts receivable have express consent to contact the consumer if the consumer has given their cell phone to the original creditor in connection with their service rendered creating the receivable? And on that one, that's one of the distinctions between what I was talking about was the do not call and Mike's section with the auto dialer and the cell phone issue. Consent. It cannot just be by using this product you agree or using your card you agree. Separately, on the account application, for example, when you're doing an online credit card application, you can put the language in there that explicitly states by by the company for business-related reasons, including debt collection calls, and you want to be very specific by stating you agree that those calls may be made by auto-dialers, systems with the capacity of auto-dialer on the application. Then revoke it, but until they do, it's consent, not consent for do not call. So that's where two distinctions. Most of you on the phone aren't so worried about the do not call. You're more worried about the latter that you could put on the application itself, but you're going to have to make sure it's very explicit and contains everything in there. And you may be charged your normal wireless rate. I mean, unfortunately, we're going to have to be lawyers and get really detailed on that.
And Katie, I'll note there are a lot more calls, and I don't think that we're going to be able to cover all these within our time. Also, I note that the questioner on the prior completes our hour, and we will follow up with folks that had these additional questions. Does that make sense? Thank you, everyone, for joining us today, and we will keep you posted on our next presentation. Katie, anything further?
Yes, if you could all